All right. Good afternoon, everyone. Thank you so much for joining us today, and thank you for bearing with us just to make sure we're all set up and ready, working through tech issues. My name is Pati Mendoza. I am the Director of Alumni Affairs here with CHCI. And with perfect timing, there's a lot of background noise. Can't control that, so apologies. But really excited to be here today for this really important conversation, estate planning basics. Before we get started, I do want to thank our sponsor, State Farm, for making today's webinar possible. This is one of a series of webinars that we've hosted this summer and fall term. So we're really excited to have Pedro with us today. Again, just sharing some really important information. Just for flow, as you heard, we want this to be really interactive. So engage with us through the chat. We will answer questions as we go. I know Pedro really wants this to be a conversation. So feel free to hop on chat at any point with your questions. We do also have time for questions allocated at the end, but invite you to join us at any point. With that, I am going to hand it off to Jose Plaza, who is our president of the Alumni Association National Board, who is going to be introducing today's guest.
Thank you, Patty, and thank you, Pedro, for joining us. As Patty mentioned, these are a series of serious sessions. I'm actually really excited for the session. You know, in conversation with CHCI leadership, we were discussing what were the type of services that alumni were needing throughout their career. You know, and through the COVID pandemic, and even before that, we've came to the stark realization that as Latinos, we need to be, you know, a lot more prepared and at the ready in order to deal with, you know, some of the curves that life brings to us. And it's important that as Latinos, we have the tools in place. And so that's where Pedro, you know, came into the picture to help us have this very, you know, timely conversation around estate planning and what as Latinos, you know, within the age spectrum, we can do to get ready. And so let me take a minute to introduce Pedro. So Pedro Rivera is the Senior Director for Individual Giving at Unidos US, with 20 years of diverse experience in donor relations, wealth management, development, fundraising, financial planning, and planned giving. During his career, Pedro was a former board member of the Greater Philadelphia Hispanic Chamber of Commerce, where he served as a board sponsor of the GPHCC Latino Professional Mentoring Network. He is the past president of the Hispanic Bar Association of Pennsylvania, past president of the Hispanic National Bar Association, and he has received the HNBA Pro Bono of the Year Award in 2014. He currently sits on the board of Somos El Poder, a Latinx fundraising institute. He lectures on estate planning and planned giving topics nationwide. Pedro received his JD from Western New England College School of Law and his BS degree in Business Administration from the University of South Florida. Pedro is a member of the District of Columbia, the Hispanic National Bar Association, the National Capital Planning Council, the Association of Fundraising Professionals, and Somos El Poder, Latinx Fundraising Institute. Again, we're very excited to have Pedro with us. As you can see from his bio, he is more than ready to share on estate planning. So Pedro, thank you for joining us, and I'll transfer it over to you.
Thank you so much, Jose and Patty, for having me, and welcome everybody on a late night today. But my name is Pedro Rivera, as he said, and I was born and raised in Puerto Rico, and I'll talk a little bit about just kind of one-on-one basic estate planning information that we should all have. I will tell you that my first experience about estate planning was when I was in law school, and I took a class on estate planning and came to the realization that there was a lot of issues that we confront on an everyday basis that our parents need to take care of. I was fortunate enough that my father was a CPA, so he had covered a lot of that stuff. But what I working in wealth management and working with the Latino community, you know, I've kind of, you know, you come to the realization that this is not a topic that we, for most part, feel very comfortable with, because we don't like to talk about death. We feel like we're going to live forever, and that's not necessarily true. That's one of the things that are guaranteed in life is birth and death. So this is going to be a kind of a basic 101. I will kind of go through the slides, and if there's any questions, please feel free to put them in the chat question portion, and Patty or Jose will stop me and say it. So I want to make sure that we're all kind of, that it's more of a conversational than and then this is a disclaimer. So what's estate planning? So I think when you think about estate planning in the traditional old form, you think about, old couples, wealthy families sitting in a law firm with, wood panels and kind of trying to make sure that their spouse is taken care of, their kids are taken care of, and that they're really back when the main purposes of estate planning was to protect the estate from taxes, estate taxes. And that's when you talk about transferring of generational wealth. And so that eventually the estate planning ended up changing. And so then we went into estate planning. Things change, as you know. Lifestyles have changed, finance world has changed, privacy issues have changed. We now have non-traditional couples. We have, combined family members. You have a lot of other issues that have changed since the early 1900s. You have a lot of blended families, and people are living longer. So the estate issue plannings are becoming a little bit more interesting, a little bit more sophisticated, and it's the parameters have expanded to a larger group of people, because not only estate planning is not only for the wealthy people, and we'll talk more about that. So in a nutshell, what is an estate planning today? Today, estate planning is about financial retirement, business succession, which is if you have a business, if you die, how does the business go to the next family member or to whoever you like to leave it to? Charitable, for charitable donations, medical, disability, legacy, and gift planning. And this is kind of like what estate planning has evolved to the day of today. So, and I'm kind of curious, just to give you some statistics, but only 67% of Americans have an estate plan. So that means only 33% have it. And then I did a little bit more research, and only 26% of the Hispanic communities have an estate plan. That's bad. That means basically almost 3 out of 10 people only have an estate plan. So if you die without any planification of what your assets are going to have to, other people get to decide, and you don't want that. So who needs an estate plan? Everyone. If you own a house, you need an estate plan. If you have kids, you should have an estate plan. If you own a car, you have an estate plan. And and clearly, the younger you are, the less assets you have, and so the things become a little bit more simpler. But I can tell you that you want to have an estate plan in place if you want to have kids, because having a kid and not having an estate plan can create issues that will complicate matters for your family. And particularly if you and your spouse were to travel on a vacation and leave your kids at home and they're under the age of 18 and die without an estate plan, and they become orphans, the kids become ward of the state until they process who in the family is going to have the kids. And I don't know about you, I don't have kids, but I wouldn't want my kids to be in foster care while the parents or the family is trying to figure out where is the best place for the kids. So if that doesn't scare some of you, if you have kids, it should. So the next thing that we have is what's in the estate. And the estate is, you have 2 different types of assets. You have tangible assets and you have intangible. The best way to describe tangible assets is things that you can touch. So you can touch a house, you can touch real estate, automobiles, jewelry, personal furniture that you inherit from your family. That's all tangible property. And then you have intangible assets, which are your bank accounts, your annuities, your stocks, your bonds, your business interests, your life insurance, and your retirement plans, which is your 401ks or 403bs, or if you work in the government, some type of retirement plan that they have. So when we talk about, so when you're thinking about your estate planning, and I'm trying to not go as fast, like just in case I don't want to get people lost. And you want to think about what are your goals for estate planning. And so you want to create a plan, and like I have in the bullet points, you want to maintain control of the estate. You always want to be in control of what you own and the things that you have and who's going to take them. You also want to avoid probate, and probate is basically we'll talk a little bit more about it, but it basically boils down to your estate being processed through the court system, and that's a very costly expense that you would try to avoid. And there's ways to avoid probate court. Also, you want to make sure that you reduce your estate and income taxes. When you die, you not only pay income taxes, but there's even death taxes in some states. And so you want to avoid that. And you can do that through estate planning through highly sophisticated financial advisors that can help you with that. You want to protect your spouse and children. Those are your biggest, they're most treasurable assets that you have, your kids and spouse. You want to make sure that you're providing for them when you're no longer with them. You want to protect inheritance from creditors. I always find this very interesting. You know, when you get married, you inherit your spouse's debt. So you want to make sure that if your spouse dies and you don't want to have to pay for her debt, you have to find ways to protect the inheritance from depleting the assets from your estate. The other thing is you want to provide for disability planning. You know, sometimes, you know, we could have spouses that are disabled. We can have family members disabled. You can have a child that has some special needs. You want to talk about, you know, you want to make sure that that child is taken care of in the absence of you know, being longer in this world. And then the other thing is you want to prevent delays related to estate taxes. Like I said, probate is a long process, expensive process that has to go through the court systems. There's things that they do inventory of your assets. They do a cost accounting of all your properties and assets, and that can sometimes take a couple of years. And so, you know, I think when someone dies and there's all of a sudden the expenses that come up, whether it's funeral cost expenses, you want to be able to have some type of liquidity and liquid assets that you can hopefully have money to do that. And the worst time to be financially strapped is when you lose a spouse or you're in a situation where you can't get the assets for a year or two. And so that's something that you definitely don't want to deal with. And so that prevents delays. And then the other thing is my favorite. You want to reduce family arguments. People say my family gets along, my parents have everything set. Believe me, when people die, weird things happen. And it's not necessarily sometimes the siblings, it's the spouses. I've had situations where, hey, you know, Juan's wife, you know, is asking me, why did you get that credenza and not me? And why, and you know, he took care better of mom, and it becomes really, really, really difficult. I'll tell you, my parents, one of the things they did, which was really helpful when they were at the tail end of their life, they gave us these like little stickies with dots, and I got red, my brother got blue, my sister got yellow, and my other brother got green. And we just went through the house and put dots on the things that we wanted. And if there was any kind of debate as to both of us wanting something, we were able to fix that and talk about it before my parents died. So it didn't become a nasty, unfriendly family quarrel about property, which is, you know, something that unfortunately people fight about. So you want to make sure that you reduce that. And then the continuity of your asset management, the property that you have, the assets that you have, your financial accounts. And I see I have a question. Could you also mention long-term insurance care? Well, I'll tell you, long-term care insurance is something that became very popular. Unfortunately, a lot of insurance companies have realized that there's not a lot about long-term care insurance, that there's a lot of insurance companies are starting to not provide that, especially but that's definitely something that you want to talk about. And then Medicaid and estate recovery, and how it's something younger folks need to be talking about their aging parents. Yeah, also, actually, you know, that's a great answer. Let me talk a little bit about that. Well, you know what, I'll address that right now. I'll tell you, I went through an experience. Both of my parents are deceased, and we had to, you know, my mom was in hospice care for 9 months, and Medicaid pays for some services, but when you have a certain amount of assets, they do not cover those assets. They don't cover the care. So we had to hire a private nurse, and so that becomes very costly. And you know, you have to kind of just realize you have to talk to your parents about these kind of expenses, because, you know, my parents were prepared to cover those expenses, but, you know, we're very fortunate, and we're not the typical situation. You know, a lot of people get stranded, and if you don't qualify for Medicaid and you're on Medicare, that's what was my parents' situation. You have to have these conversations with them and see whether or not you can get long-term care for your parents. We have long-term care for my mother-in-law, so that when something happens to her, we won't have to put an asset or a dime from our pocket to protect our assets and their assets. So that's a great question, and thank you for asking, whoever asked that question. So then the next slide I have is the basic estate planning documents. And you have on one side, you have the distribute of the estate, which is your last will and testament, a revocable living trust, which we'll talk a little bit more about it. And then a ladybird deed, which actually a ladybird deed is, well, by definition, and I'll explain what it means. It's a transfer of property to another with a reservation of a life estate. And the best example I can give is usually when you a second marriage. So the spouse owns the house, marries a woman or a man, whoever they like to marry, and the house is under the one of the named spouses. But the husband, the owner of the house, wants to leave the assets to their kids. So when he dies, he puts a provision that his wife can live there until she dies, and at her death, the proceeds of the sale of the house go to the kids. That's a ladybird deed. So, and that's mostly to protect the children if it's like a later marriage or it could be also if the other spouse owns property and doesn't need the financial the need for the financial need, but wants to be living in that house just for stability and continuity. The other thing is the financial power of attorney, which we'll talk more about it later, and then the medical power of attorney and a living will. And these are all basic documents that you should have on top of providing for your children, which is an appointment of a guardian. An appointment of a guardian is someone that will take care of your kids if you were to not be, when at the time that you're deceased. And so you definitely want to have that. Actually, I have another question. My dad left the house to his grandchildren, but placed it in my brother's name, and now my brother's not following up with it. Can something be done? He has dementia at the time placing my brother's. To be honest with you, Brenda, I'm not here to offer advice, but I would tell you that you should talk to an attorney about that, because there's definitely some legal issues pertaining to your question. I think it's a great question, but I would consult a professional from the state, because probate law changes from state to state. So that's my recommendation to you. Thanks for asking.
Pedro, we also have a hand raised. Do you want to start taking questions live?
Yeah.
From folks as well?
Yeah, sure.
Perfect. Jeff. Jeff, you're unmuted. Jeff, did you still have a question? Okay, we can circle back to Jeff, or he can also add that in the chat.
Okay, I see another question on the chat. Oh no, it's the same question. Okay. Hold on a second, I can't. Oops, I want it to go. So the next slide, as you can see, it talks about what the last will and testament, and basically the basic definition of a will and testament is it's a set of instructions for distribution of your assets, your property, that take effect upon your death. And that's usually what we usually see in movies when the family gets together and they read, and the estate is left to so-and-so, and people faint and all that kind of crazy stuff. And I have to say, the issues with the last will and testament, that all the assets that are disposed through a will must go through probate, and that becomes an expensive proposition. So I'll talk a little bit more about that. So here's the things what property does a will cover. And so as you can see, a probate property, it's all property in the decedent's name. So it's anything that's under your name, your house, or any other real estate, and that all has to pass through probate. What you want to look at is the non-probate property. And when it talks about joint property, that means usually when you buy a house, like I own a house with my husband, and we have it, the title is joint property with the right of survivorship. That means that if the moment that I die, he owns the house, because he has the right of survivorship. If he dies, I own it by the right of survivorship. So that doesn't have to go to the court. Life insurance policies, you always name a beneficiary on your life insurance policy. So if you die, you have to just basically show the death certificate to the insurance company, and they then send you the check. The same thing with retirement accounts, 401ks, IRAs, 403bs, all those kind of retirement accounts that have, you name a beneficiary. The only thing I will say about retirement accounts is if you're married, just beware that your spouse is entitled to half of your retirement account. And if you get divorced, make sure that you negotiate that aspect of your retirement, because married couples inherit each other's retirement accounts. And even if you don't want her to, you don't have a choice. By law, she inherits it. The next thing is what's called a POD, which is payable upon death, and that's usually that's basically bank accounts, so your checking account, savings account, CDs accounts. They all have a designation in the bank, and so when you die, you just go to the bank, you show the death certificate to the bank, and they write you the check. So what is probate? So I know I've been talking a lot about probate, and probate is basically a court supervised process which transfers the title of your assets to your heirs, which is your family members, kids, spouses upon your death. Probate is, like I said, it's expensive, it's time consuming. Sometimes it can take years to settle an estate. I'm sure you've kind of read the Michael Jackson, all these famous people in Hollywood who die and leave a will, and it takes years for the assets to be distributed to the beneficiaries. It's cumbersome. I tell you, I worked in wealth management, and we had an estate administration process. And when someone dies and has to go through probate, you have to go to the house, you have to take inventory, you have to list all the assets, you have to get appraisals, you have to go to court, you have to do a court accounting. It's very expensive. And also it creates an issue that credit claims can include possible Medicaid claims. And just to know that probate is completely avoidable. So if you do have a good estate plan, you want to avoid probate. So that's the main lesson, is trying to avoid probate. Is there any questions about that for this far? So the next topic I'll talk about is a revocable trust. So revocable trust is a set of instructions to care for you and your family during your lifetime, during incapacity and after death. Basically, the best way I can describe a trust is kind of like a vehicle that you put all your assets in. So it's like, think about a big bucket that you put all your assets in, all your accounts, your houses, and they're named under the trust. The good thing about a revocable trust is that you're protected from creditors, and the assets when you die are not disposed through probate. You will not be, and it's a great tool. It's a tool that a lot of people transfer generational wealth through trust. A revocable trust means that you can revoke it at any point during the person's lifetime. If it's irrevocable, which is it means that you cannot revoke it until the person dies, the beneficiary of the trust. So there's two different trusts. The revocable trust, to be honest with you, a perfect example of a revocable trust could be if you have a daughter and she's getting married to some guy that you don't particularly like, or a girl or boy that you don't like. You want to buy her a house, you buy the house under and you put it in trust. If they end up marriage ends up not being successful, the husband's not entitled to the assets of the house because the house is owned by a trust and not by her. And a lot of wealthy people, or people who buy houses to their kids, who don't like their significant other, do this. It's a great way to protect your family's assets as well. So then we'll see here the irrevocable trust avoids probate, and it kind of shows you the graph kind of shows you. So a last will is the decedent's property, which is the person that died, that goes through probate court, and then it goes to the heirs. If you do a revocable trust, you have the decedent's property, the person that dies property. You don't do probate, and it goes directly to the heirs. It's a much faster, cheaper way to transfer wealth to your significant others or family members. And these are other benefits for a trust, and I'm just going to highlight someone. Clearly, avoiding probate is one. The other one is reducing estate and income taxes. We all love paying taxes, right? Not really. So there's ways to be legally that you can create ways to reduce the impact of taxes on your estate. Once again, you want to protect your spouse and your children, protect your heirs from inheritance from creditors. Provide the disability planning, it's really important because, there is special trusts that are called special needs trusts that allow you to provide income for life for a kid of yours who might be autistic. I mean, I have two nieces and nephews that are have autism, and we have created a special needs trust within our family to make sure that when we're no longer around, that they have the necessary financial support to be able to live independently or live with the support and help that they need. And that can also happen with parents as well. So it's anybody or your spouse. Your spouse has an accident, becomes disabled, and there you go. And then of course reduce the possible disagreements with the heirs, and avoid the probate administration and cost. So this is a summary of the differences between, and I can provide this presentation after, if anybody wants it, I can provide it to Patty and she can send it to you guys. I don't have an issue sharing it. But this just kind of shows the differences between a last will and a revocable trust. You see the advantages of a revocable trust compared to a last will. You usually still have a last will and a revocable trust together as part of your estate planning. And so I would once again strongly advise you to talk to a professional. If sometimes people ask, hey, I don't have the money to hire an attorney. How do I feel about those? There's a lot of the Zoom legal and all these different web-based forms that offer, something. Well, to be honest with you, if you cannot afford an attorney, something like that is better than nothing. But I tend to be a little bit hesitant to use them myself because, like I said, probate laws can change from state to state, and you have to make sure that you're trying to use a form that follows the laws of the state, I guess, for lack of a better word. So, but to be honest with you, there's a lot of resources. There's a lot of the Hispanic National Bar Association is the largest Latino bar association in the country. They have pro bono services, and then pretty much if you live in any metropolitan big city in this country, there is the DC Bar, there's the Philadelphia Bar Association, Hispanic Bar Association, New York City, California, there's tons. So you can always go to that. And the other thing I would also suggest is that there's a lot of the law schools have clinical programs that offer these services for free or for a sliding scale. And also legal services, I believe, offers it as well too. So there's ways to figure out how to make sure that you do an estate plan. The next thing I want to, yeah.
Sorry to cut
okay.
you off.
Yeah.
There, because you were talking about trust, there was a question around irrevocable trust.
Yeah, an irrevocable trust, it's a revocable trust, but it's irrevocable, meaning that a revocable trust, you can change it, terminate it at any point of the trust lifetime. Once it becomes irrevocable, it does not terminate until the beneficiary of that trust dies. So if that person lives another 30 years, you cannot amend that trust. And so that's why most people do revocable trust, because they have more flexibility. And irrevocable trust was an old way that old wealthy families would leave money in trust for people, and they would receive income for life. And then when they died, then it would go to another beneficiary. What's the range price for, to be honest with you, it really depends. Brenda, it could be a solo practitioner that might, I would say that my guess is that anything between 1,000 to anything above. It really depends the experience of the attorney, the relationship that you have, but it's going to be a couple $1,000s. You might be able to find someone who'll do it for 500, but I haven't really done it. I haven't done one in a really long time, but I think you can shop around. But if you look for a solo practitioner that does, and make sure you do that you look for an attorney that does trust and estate. Do not hire a criminal defense attorney to do your trust, because they don't know what they're doing. In the legal world, we have specialists, and sometimes people do personal injury, wills, trust. There's plenty of solo practitioners that focus on trust. And for Brenda, the Hispanic Bar Association of Pennsylvania has a good group of attorneys that have them, and the Hispanic Bar Association has a couple of people that I've used when I lived there, because I lived in Philly for 20 years. And they're very reasonable. So it could range, but it's depending how big the estate is and how complicated the revocable trust is. And then what type of attorney should we be looking for? You also meant it should be a trust and estate attorney, one that specializes in wills and trusts. And to be honest with you, a good person to ask is a financial advisor. Like most of us, if you have, oh great, Brenda, you're from Philly. Fly Eagles fly, just a little bit there. Anyway, getting off topic. The attorney, usually your financial advisors are great people to refer you to trust and estate attorneys, because they work very closely with you. Usually a financial advisor has an attorney to help their clients create an estate plan. So that's a good route to go through. So anyway, I think that answers Jeff's question. The next question is the financial power of attorney. And this is basically when someone becomes incapacitated, and the definition of incapacitated is a lack of physical or mental cognitive ability results in a person's inability to manage their own personal care, property, or finances. And the reason I'm describing the definition, because this is a debatable situation, because incapacitated to one person can be something, to another can be something. But usually it's someone who's not in a position to be able to make a financial decision. It's not someone that's not good in finances. It's incapacitated, that they don't have the cognitive. They don't have, they can have Alzheimer's, or or any kind of, they're in a coma, they cannot make a decision. And so this is really critical to have, it's because, I can tell you that in my parents' situation, we had a situation where we had to use some of my father's resources to pay for some stuff in the moment that he was incapacitated before he died. And we were able to use his assets to pay for some of his care. So you want to make sure that you have a financial power of attorney. I highly recommend someone that you trust, someone who's fiscally conservative. I usually would try in the family to find a CPA or someone who you can trust, because this person has a lot of power on the person's account. So I put someone that's fiscal responsive, a CPA, an accountant, financial planner, an advisor, anything like that. So the benefits of financial power of attorney. So clearly the advantages is that you prior to becoming incapacitated, you've named someone that you trust, someone that will be a good decision maker. It also allows the family members to assist the incapacitated member, and you facilitate the process. I've been through this process, and it's very stressful to see your parents deteriorate to the point of dying. And there's so many other things that you're thinking, and all these things just make the process easier and less stressful for you. And also, you want to prevent a conservatorship. And a conservatorship is a legal status which the court appoints a person to manage the financial and personal affairs of a minor or incapacitated person. You don't want the court to make decisions for you. You never want to make the courts make decisions for you. You'll never win. That's not a good situation. So you want to make sure that you have, and usually financial power of attorneys come with another power of attorney. So it's usually like a whole package deal. And like I said, it provides continuity for investments, because sometimes the person is capacitated, they have an investment account, you have to sell assets, you can be able to just, you don't have to find out money from another place, you can get it from their financial investment account. Like it must be executed while in person has capacity, meaning the person has to be of sound mind. So you have to make sure that you do that before you become incapacitated. So then the next document I have is the medical power of attorney and a living will. And a living will, to be honest with you, many people, if you've been to a hospital, they usually make you file documents designating someone as your agent. And that's someone who represents you. Usually if you have, when you have surgery, you'll name your spouse or your significant other or your parents. And if something were to happen to you, then they can make medical decisions, have you become incapacitated. But also the living will is expressing your final wishes regarding the end of care of life. My parents, for example, did not want to be resuscitated. They wanted to be, once they got to the point of hospice that there was no other means for them to live, they just wanted to just let them live in peace and pain-free. And so this just makes the decision easier for the family. And I have to tell you, this is a conversation that you really need to have with your family, your siblings. When my parents did all this stuff, I'm one of four, we all sat down, talked about it. And if there was any little sense of objection, we just needed to talk it out, because I can tell you that my spouse is a nurse. And if one of the siblings decides that they want the person to live a little bit longer, or is not in agreement to let the person, they want the person to be resuscitated, it creates another issue. You might have to go to court. It prolongs. It's a mess. And so you want to make sure that these conversations that are difficult conversations, you have to have them, because at the end of the day, like I said to you at the beginning, we all are guaranteed to live and to die. So you cannot get away from that. So the next thing is a medical power healthcare surrogate. And that's usually someone that you as an adult designate another person to make decisions regarding your healthcare. This is usually very, very common among parents and children, that your parents might ask you to be their healthcare surrogate. And so you kind of make sure that they are taken care of with their health care. And then also you are the one that's in charge of making any funeral arrangements in the event of their death. So, and one of the things, you know, and I hear talks about HIPAA, and HIPAA is just HIPAA is a protection of privacy that, you know, medical hospitals do not provide access to your medical records unless there's authorization from your agent or a release or a disclaimer, or I mean, a release to allow you to do that. But, you know, it's really more important is that you can be a healthcare surrogate for one of your siblings or your kids. And then I believe that's one of my last like the living will. And like I talked about it a little bit, it's a different kind of a will. It's the written expression of your wishes regarding the end of life care, which is provided to your family and doctors. And usually when you go to a hospital, I have a living will, I have a copy, I take it to the hospital. It talks about, I don't want to be resuscitated. I don't want extra care. I don't want anything beyond the normal care. And if I go into a coma, unplug me. And those are my wishes. And you want to make sure that you have this because, you know, I mean, I don't know how old you guys are because I don't really know the age range, but I don't know if anybody knows about the Terry Schiavo case in South Florida and Tampa, where this woman was in a coma for years and years, and then the husband wanted to basically turn the machines off, and the parents didn't want to, and it was a whole long, crazy battle until he won, and they turned off the machines. You don't want to do that. These are very difficult, stressful times, and you know you want to make sure not only that you have it in writing, but that you express it to your family member that if I'm in a comatose and it's irrevocable and I cannot be brought into normal life, I don't want to live, and make sure that's something that you express. I mean, a lot of these documents are really critical for you to have conversations with your family, with your friends, and your kids. You know, I mean, it's a difficult conversation, but you must have it. And then I believe the glide is starting the conversation. Like I said, you know, there's a saying in Spanish, la gente cuando habla se entiende. You know, when you speak, you understand each other. The importance to talk about your assets that remain under your care. Where do you want them to pass to your children? You know, you can have situations where, you know, I've had situations where, you know, they have 4 kids and one of the kids is an addict, and they want to leave the money in trust because they know that the kid, if he gets the money outright, he'll go through it. So, you know, all these kind of conversations that you want to have. The other thing is, when was the last time that you reviewed your beneficiaries for your life insurance and retirement accounts? I do them every year, and that might be a little bit excessive, but you should do it in any life significant change in your life, a death, a marriage, a loss, your kids turning 18, things change, have anything that's significant in your life, you know, you win the lottery, and actually I'll talk about, that's the next slide. But you want to make sure that you have the conversation, and these are kind of just triggering questions for you to think about and have conversations with your family member, spouse, and, you know, your financial advisor. I'm sure everybody here probably has a 401k. You know, they can help you talk to an attorney, or you can start having conversations about what's right. And then this is like another kind of checklist, you know, when recent good fortune, to check your estate plan must be updated. Change in family relationships, divorce, marriages, death, become a parent, a grandparent, the loss of a loved one, incapacity of a spouse or a loved one, a change of address, a foreseeable need for a nursing home. Someone asked about parents in long-term care, you know, and your children who are growing up, because once they turn 18, they're adults, and so those things change. And then, you know, desired changes. You might, you know, decide that you want to leave 30% to this kid and 40% to the other kid, and so you want to make a change. So it could be all those kinds of things. So I think with this I come, I think, to the end of my presentation. So I'm opening it up for questions. It's 7:46, so I believe I'm on time. So thank you so much for having me, and feel free to ask me questions or put questions in the chat.
Gracias, Pedro. This was really informative. I really appreciate you sharing all this information. I know it hits home for a lot of us, and something we all need to think about, and often don't until sometimes it's too late and we're trying to figure things out, right? So this is really helpful. I know we have some questions in the chat, but if folks, if you just raise your hand, I unmute you, and you can also ask your question. as well. Jose, I see Jose's got a question.
Yeah, can I start off the Q&A section? And Pedro, this was super informative, and I know you're just scratching the surface of how complex the issue is. But I know that in a lot of Latino households, there is this mistrust of like legal proceedings and, lawyers, no offense, of folks handling, your life savings and whatnot. Is there a process where you can get, a trust in place or whatnot without the cooperation of your parents? Let's say like children wanting to, provide a pathway or something, but if the parents are like hesitant or, mistrust the system, like what can be done to plan around them or for
Well, I
them?
mean, you can definitely do that with your assets, but not with your parents' assets. I mean, yeah, I mean, if I wanted to take care of my parents and I want to put, $2 million or whatever amount between if your siblings want to create a revocable trust for the caretaking of your parents, that's fine. The question is, if you're going to use their assets, they need to be agreeable and they need to understand it. So it's a matter of consent, and there is the revocable trust you can create for anybody, but it's the assets that you put inside and who's the owner of putting the assets into that trust. You can do it if the siblings have sufficient means to create one for the parents. You can do that. But if your parents don't want to use their money for that, it's really hard. I mean, to be honest with you, I think one of the things that, and I know because I was born in Puerto Rico. My grandmother, when I was in college a gazillion years ago, she would send me like $20. This was a post mail, which nowadays that's crazy. People could open the mail, take $20, and I would never see it. But these people had their money underneath their bed in a coffee tin can. And I think a lot of it is just trying to find organizations, and there's a lot of nonprofit organizations that talk about financial literacy that can help them, educate them at a very basic level, and they maybe even find people of their generation that can talk to them about it. That level of distrust, to be honest with you, is what's hurting us as a Latino community, because we're not learning about compound interest, which is putting money in an investment account like a retirement account. That money grows. As much as people talk about the stock market by far is the highest income generating investment in the history of this country since 1934. Even when the market goes down, that's a given. I just think people, a lot of people get all freaked out about it. And I have an aunt that every time she has all these CDs and she just keeps rolling them over, and I keep telling her, I realize that's a safe investment. I mean, at this point of her life, she's an older woman, so it's okay. But there's the importance of learning about financial literacy. The earlier we get into that picture, and like I said, there's organizations that do a lot of financial literacy programs. It's critical to bring the parents into the conversation. And to be honest with you, I mean, even in the financial literacy programs, sometimes there's war stories about people saying, your house burned down and you had $5,000 in your mattress and that money is gone. And you cannot get that money. If you have $5,000 in a bank account and the bank gets robbed, you're protected by the FDIC up to $100,000. So it's just a part of it is educating the parents to learn more about that, and and just trying to help them. I mean, you can only you can take a horse to the river to drink, and he only drinks if he wants to. So, but it's a challenging situation. But there's ways to massage it and make it a little bit easier. So. I see questions, I think. The other thing I wanted to touch, I mean, I realized I threw a lot of information to you guys, and I wanted to also talk to you a little bit about funeral planning. Funeral expenses are outrageously expensive. My parents bought their funeral plans like 25 years before they died. And when they died, it made the whole process even easier, because the only thing we had to choose was basically the clothes that were going to be on the casket and the color of their tombstone. And I realize that that's not necessarily everybody has the means to that, but there's ways to plan for funeral expenses that can be relatively cheaper, because a funeral can cost you between $25,000-$50,000 at a hit. And I don't think people realize how expensive funerals are. But that's just food for thought. For married LGBT couples, are there any additional steps that folks? Well, to be honest with you, since gay marriage was legal, the LGBTQ couples are covered basically under the same protections that married couples. So they don't need to do any additional steps that they had to do when I used to work in wealth management in the late 90s, where gay couples were not allowed to get married. The marriage created a protection to gay couples that was huge. What should we do if one parent dies without a will or trust? Well, hopefully that will not happen. It depends how many assets they have or not. But if they died intestate, if your father dies and your mom's alive and the house is owned sort of joint tenancy of the right of survivorship, your mom owns the house. The thing that comes to, for a will or a trust is really the number of assets. But if they own a house, it's, and then of course all the financial bank accounts, if they have a name of the beneficiary. So, well, I mean, the only thing about dying with a will is if there's things that need to be resolved that cannot be covered as a result of his death. So I don't recommend it. I mean, even having a basic will through Zoom Legal, or there's all these other companies that have come up, do just a basic stuff. But Jeff, once again, I highly recommend for you guys people to talk to professional attorneys that do trust and estates work in wills and trusts in your state, because each state, like I said, the laws differ from state to state. What are the resources we should check out to learn more about estate planning issues? To be honest with you, all the Vanguard, Fidelity, all these financial services places, if you do estate planning, you can find tons of information about that. If you go to podcasts and you do financial planning, estate planning, there's tons of great, there's a lot of great stuff on financial planning and estate planning. And they're free. Some podcasts are free, but a lot of the estate planning, to be honest with you, if you go to, actually, I work at Unidos US, and actually I'll put it on I don't know if I can put if you go to Unidos, everyone, I'm going to put the website to Unidos website. And if you go to Unidos US and you go to, if you go to our website and you hit donate, and when the donate has a little plus sign and it goes to plan giving, in the plan giving, there's 10 documents that you can actually let me see, that we provide to our donors that has a lot of good information about estate planning. Actually, I'm gonna go now and go ahead and provide that to you guys. I'll provide the link so you can look at that. And I'll tell you it's good because not because it's mine, but because I want it to specifically be as basic as possible for the community. If you hit that link that I just sent I don't know, does everybody have access to that link that I just sent?
If they don't see it, I'll make sure that I share it in the follow-up email with the PowerPoint and resources.
Yeah, within the plan giving, I have a plan giving booklet that will tell you, that has things about a bequest, frequently asked questions, estate planning, a gift from your IRA, gift planning quick guides, gift of life insurance. It talks a little bit about gifts, but it does have planning your will, retirement planning assets. So it's a lot of good information, and all those pamphlets are free. So I feel free to get those if you want, and you can download them and all that kind of stuff. So it's all good. If you have one more question, what are the reasons? Oh no, I think I already answered that. So I think we have 5 more minutes. So there are 4 more minutes. I don't know if anybody else has any other questions. Oh, I see one more. Someone put a question. Could you talk more about winning the lottery too? I know, la esperanza del pobre, the poor man's hope. To be honest with you, I'll tell you a really interesting story about winning the lottery. If you win, all of a sudden you win a couple $1 million, and all your primos, tias, extended family start showing up saying how much they love you and how close you were to them. I'm kind of the person that I think if you win the lottery, you win a lot of money, I would keep it very quiet. I would hire an attorney and a financial advisor and keep it very secretly before you talk. But the first thing I would do is I would hire a financial advisor and an estate planning attorney to help you navigate through that process, because $3 million sounds like a lot. It's not a lot of money. I mean, it might sound like a lot. People go to the $3 million in a heartbeat, and you want to make sure that you preserve your wealth, that you provide for your family. So I would highly recommend. I know that I ever win the lottery with that amount of money, I'm calling my friend who's an estate attorney and my financial advisor, and we're creating a plan. And then if it's a lot of money, I will be able to provide to my nieces and nephews in a way that I want to, not the way that they want to. So the other significant event is also if you inherit money from someone, you might, sometimes people inherit money from a family friend, and so that's a less significant event. That's a time to look at your estate planning and consider doing other things as well. So, but if anybody doesn't have any questions, I think we're good. Thank you so much for attending this. I enjoyed it, and hopefully you got a little nugget or two from this. But the one thing you have to take at the end of this whole seminar, get your estate plan in order. And the earlier you do it, the better you're off. And find ways. There's resources, and we're savvy people, Latinos, and we're educated. We have resources, we have networks, and so you just want to make sure that you're protecting your plan. So, should we making a plan even if we're 23, no kids, and not married? Well, do you own a house? If you own a house, you should, because if you die, who do you want the house to go to? So, yeah. It all depends. It's very specific oriented, but it doesn't hurt at the age of 23 to talk to someone or do readings. There's plenty of stuff on the internet that you can talk, but you can get sometimes they'll give you free consultative offers. If you're 23 and you have a 401k from your company, you can talk to your financial advisor and talk about that too. And that's usually for free. So.
Well, Pedro, thank you very much for joining us today, for sharing this, really helpful information. I appreciate your willingness to share your slides with the group. I'll be emailing all of this information and the links you shared as well first thing tomorrow. So thank you again for your time. And I will actually pass it off to Jose, see if he has any closing remarks for the group as well.
No, just echoing the sentiment. Pedro, thank you again. As you saw from the questions, folks have a lot of interest in this, and I would love to hear more and hopefully do deeper dives into all of this stuff. I think it's really timely information. So thank you again, and thank you to Caroline, who I know is in the audience, for pushing us to have this subject as part of the series. So thank you all.
Great. Have a good night.
Thanks to our alums. We had a good number of alums join us today, so we appreciate you all. Have a good evening, everyone.
Bye.
Bye.